What was the most badass escape you've ever made? There's a case clock made in the 18th century that has been in my family for over 100 years. The firstborn child normally inherits the clock. That is, until my grandparents had my uncle. My uncle has been a frick up since he was a teenager and always has relied on his parents to help him out, no matter his age. When he was in his late 20s, he flew to Taiwan and spent all of his money on stupid crap and needed to have my grandmother wire him money for a plane ticket. All the time that he couldn't pay his mortgage on a house that he could never afford, and also quit his job expecting my grandmother to pay for it. She gave him $20K in agreement that if he didn't repay her then he give up his right to inherit the clock. Over the years he seemed to forget that the clock would never be his and had a friend appraise the clock with the appraisal calling it Uncle's name, Clock. Uncle never repaid the money he borrowed. He peed my grandmother off enough for her to write him out of the will for tangible personal property, aka items the clock. He takes the executor of the estate, my dad, to court for the clock. My dad just has his attorney represent him. Uncle wants to be allowed in the courtroom with his attorney, but my dad's attorney says, no, that's not fair since my dad isn't there. Judge agrees but uncle pouts about it and accepts. The trial lasts no longer than 10 minutes. The will is evidence saying that uncle has no claim to the clock. Uncle's attorney submits the appraisal but my dad's attorney gets it thrown out because it's not proof of ownership and it was written by my uncle and his friend. Attorneys and judge agree that he has no claim to the clock. My uncle is allowed in but wants to go on the record even though the case is settled. My dad's attorney rolls her eyes but agrees. He states that they were in court because he was supposed to inherit the clock but did not. Dad's attorney states that he has no legal claim to it. Uncle's words were, well, I suppose it was always just matter of ethics than legality. My dad's attorney, baffled, states, then what are we doing in court? Homeboy got clock blocked. When I was clerking for a judge in my first year as a lawyer, we had a case that centered around if a person could lawfully shoot a dog that is attacking his chickens. The law said that he could shoot him if the dogs were bothering or wounding the chickens. Plaintiff was suing for the value of his dogs that were killed in emotional distress. His argument was that the dogs were not bothering or wounding the chickens because they were running away when the farmer came outside with the shotgun. He then argues that wounding has to be active. So he gave an example. If the dog has a chicken in his mouth you can shoot. If he drops it but the chicken is floundering right in front of him you cannot shoot as the wounding has ended. Picks it back up, shoot the mutt. Lightly paws at it, not wounding. It was ridiculous and inconsistent with case law. I wrote the opinion awarding defendant summary judgment. Here comes my favorite part. Plaintiff asks for a reconsideration based on a single word I used in a throwaway line in the 8-page opinion. I said it was reasonable to assume that the dogs were still a danger to the chickens. During the reconsideration, the partner from the firm comes for plaintiff instead of Joe Schmo and says, frankly judge, I have always thought you were the finest attorney in the region. So I'm shocked you got this so wrong. It's baffling to me. Judge didn't react but I was plenty offended on his behalf. So I am tasked with writing the reconsideration opinion. I wrote a 2-page summary of the hearing with no indication on the 2 pages which way we were leaning, then pasted the original 8 pages but with the sentence about reasonableness omitted. I wish I could have watched that lawyer read 3 pages deep to realize it was the exact same decision as before. In child support, Your Honor, I already have 3 children that I pay for. I can't pay for a 4th. Are you the father of this 4th child? Yes, and I cannot afford her. I have 3 others. Ordered to pay full support for the 4th child to the surprise of no one. In spousal support, I'm an iron worker by trade, but I work in coals. Why don't you work as an iron worker? Certainly it pays more. They expect me to work weekends. That ain't happening. Ordered to pay full spousal support on an imputed income of an iron worker. In criminal court, for harassment, I sent pictures of my testicles to her, XGF, to see if she thought one looked too big. It was medical, not harassment. What about the picture of your dong? Same. I thought it looked weird, like I was sick. I needed advice. Is your XGF a medical professional? Number. What is her profession? She's a kindergarten teacher. Turning your attention back to the pictures you texted, you said they were medical inquiries made to your kindergarten teacher XGF. Correct? Yes. What about this photo, with the caption "suck my dong"? Was that also medical in nature? Defendant wanted to take back his guilty plea, arguing that the only reason he pled guilty was because he had to take a huge crap at the time, but didn't want to do so at the courthouse. Another defendant argued that his was denied the effective assistance of counsel because his defense counsel permitted him to plead guilty to a DUI 20 years ago, after the guy crashed his car into a wall and was drunk off his butt at 5 AM in January. His defense was that he crashed his car, then in the 30-minute 1 hour waiting for the police, walked in the freezing cold to a liquor store and drank a whole bottle of whiskey, and so he wasn't technically driving while intoxicated, but became intoxicated afterwards. The judge described the guy as either highly courageous or highly foolhardy for offering that story. The different defendant claimed his guilty plea was not knowing, intelligent, and voluntary, and therefore, invalid, because he was high as crap off C and alcohol when he came into the courthouse at 9 AM. I've responded to countless motions from defendants who've said that they didn't know they'd be deported if they pled guilty, even though the judge explicitly told them exactly that. One defendant claimed that he couldn't have committed the robbery by climbing through the bathroom window because he has arthritis and knee and hip problems. He testified to this, despite knowing that we had security footage of him climbing in through a window of a church, also to rob it, then jumping up and climbing out, and despite knowing that the judge was going to allow us to show it to the jury if defendant opened the door to such evidence. Non-citizen defendant who's a level 3, highest, diddler argued that his designation should be lowered removed because he was deported, and therefore, he doesn't present a danger to the community anymore. Lawyer here as well. Literally anything that the constitutionalists, pro-we, are you detaining me sovereign citizens makes. This stuff goes back a long time. 20 years ago I was getting the "they're impeding my freedom to travel" and now it's the "I'm a corporation" arguments. I really wish people would stop believing that the law consists of magic words and incantations that lawyers have hidden from you. It isn't. They don't exist. You are driving us all nuts and you make the judges angry at you. Ridiculous argument I made. Client was arrested for failing to appear. She fell asleep under the trailer of a truck at a carnival she traveled with and they drove off and left her there on the ground. Argument. Your Honor, she didn't miss court to disrespect the court. She's just stupid, right? You're not exactly the sharpest tool in the shed. Client sheepishly nods. Judge drops the charge. In an aggravated assault case there was a clear video from the Walmart parking lot of the defendant getting on the passenger side of a car, riding a little ways, and then hopping out to rob a guy, ultimately shot victim in the stomach. Police stopped the car soon after 911 was called and the guys were arrested. The defense refused all offers for plea deals and went to trial based solely on the defense that the driver and passenger switched seats, with the car still moving. In the 10 seconds between him hopping in and hopping out, it was his third violent offense and the defendant got life in prison. So an important part of any legal case is that both sides be able to depose the other side's witnesses. This usually includes the plaintiff. My client was a very elderly woman who was hit by another car in a parking lot. She was not in good shape and had trouble getting around. Twice during the case the other side scheduled a deposition. Twice during the case my client showed up at our offices on time for the deposition, and both times, the other side did not appear. They never informed us, or our elderly, disabled client, so she made the 30-minute trip to our office for nothing. At no point were any depositions cancelled from us or our client. Those were the only 2 attempts made by the defendant. After the second time they cancelled the deposition, they filed a motion in court to get our case dismissed on the grounds that they didn't have a sworn statement from our client yet. Again, this was entirely the defendant's fault, but they filed a motion to dismiss the case against our client. When asked at the motion why they cancelled the second deposition, they even said that the attorney responsible had a personal conflict. Thankfully, the judge didn't even give it a second thought and denied their motion. A lawyer here. I sued the local sheriff in charge of running county jails here for not providing a voter registration application to inmates who request it. Instead, the sheriff had them fill out another form requesting both the application and a pen. His attorney initially argued that it's because the inmates don't have access to a pen. When I pointed out that a voter registration application can be filled out with a pencil, he changed his argument, saying that they don't have access to a pencil either. So I asked him, how do inmates fill out the request form for a pencil then? With their blood he dropped that argument and settled. I'm a lawyer. I should win right there. Anyway, we were in trial, and opposing counsel was objecting to a document I was trying to enter into evidence through one of their witnesses. The witness had identified it as one of their business records, but opposing counsel objects. Jury is in the courtroom, so the judge has us approach. We do, and opposing counsel argues the authenticity of the document. I was a little surprised, so my response was, Your Honor, this is their exhibit. Is counsel stating they submitted inauthentic documents to this court? Judge turns to counsel. Are you submitting non-authentic documents? Opposing counsel stammers out a no and the document goes in. I was a little surprised they wanted to argue their own document wasn't authentic just to keep me from getting it to the jury. This happened like a week ago. The criminal defense attorney representing a guy who stabbed his wife several times and then beat her with a frying pan and then stabbed her again tried to argue that it is an affirmative defense to attempted murder if you take your victim to the hospital after. He claimed it's impossible to attempt to murder somebody if you save her life after. He got bench slapped pretty hard. 1. For the horrible legal argument, and 2. For continuously saying this guy saved her life after he tried to kill her. I am a lawyer. This was a petition, rather than an in-court appearance, when I was a pro se clerk. Pro se clerks handle petitions from prisoners. This was a state case and the petitioner claimed that because our state awards good time credits, for every 30 days you serve without problems you get 10 days off of your sentence. For all sentences, even sentences of life. He had accumulated X years of credit against his sentence. Further, according to the actuarial tables, he would be dead in X years, therefore he was eligible for release. So far this is a clever argument, even if it is bound to failure. What made it ridiculous was that he was not serving one life sentence but 2 consecutive life sentences plus 20 years. Therefore, under his own analysis, he needed to serve more than his own lifespan before becoming eligible for release. As an added bonus, I dismissed his petition as lacking standing until he actually died and we could properly calculate his sentence. Not mine, but my old mock trial instructor. And how do we know that? Witness S testimony is reliable. To witness you need to wear glasses, correct? Yes. So doesn't that mean that you are legally considered to have impaired vision? Yes. Prosecution proceeds to build most of their cross-examination on this leg, painting the witness as unreliable because of poor vision. Finally, defense gets a chance to question again. You wear glasses, Mr. Witness. Is that correct? Yes. So whenever you're wearing glasses, you have 20/20 vision, correct? Yes. Thank you. No further questions. I wear glasses and you would be amazed the amount of people who seem to think I can't see as well as them when I have my glasses on. I wear them for a reason. I was a state witness in a parental neglect trial. As an LCSW, I worked for a mental health substance abuse hospital evaluating children and teens for admission. The state was asking to have the kid removed from the home, in part due to information I reported as I had interviewed and admitted the kid on 3 separate occasions. During one eval, the mother shows up so high she can barely talk. The kid admits he gets all his drugs from her. The other evidence comes from info gathered during the kid's inpatient stays. So this is a very rural area with only 2 hospitals in the entire state. As such, I didn't work in the hospital nor was I part of the inpatient staff. I lived 3 hours west of it, covering the 22 counties on the west side of the state. The prosecution had sworn statements and records from the inpatient staff and called me because I lived in the jurisdiction of this court and could testify in person. So all of this information was introduced the minute I took the stand. The defense lawyer basically repeats all of this and then proceeds to try get me to support his defense that the inpatient treatment was inadequate. How this relates the mother giving the kid drugs no one ever figured out. He has absolutely no witnesses of his own, no character references, no other hospital staff, nothing but the state's evidence and me. He repeatedly asks if I agree with his statements that X occurred in treatment or that if Y would have been a better option. After like the 6th time of me stating I was not able to answer the question, The judge cut him off and asks if he has any other line of questioning. The mother whispers in his ear and he says yes. He has one more question. Do I think the mother is a fit parent? I was stunned. I looked around at everyone and asked him, are you asking me in my professional capacity if I think the mother is fit to parent? I see the state just kind of smiling and shaking his head. The defense is certain and says that's what he's asking. I look at the judge, who smiles and nods at me to answer, so I say, no, in my professional opinion she is not currently fit to parent. Everyone else is trying not to laugh, but the defense looks so disappointed I almost felt sad for him. I don't know WTF they were thinking, but needless to say, the state won. Not a lawyer, but my dad was, and this came directly from him. It's the late 70s, early in my old man's career. Client gets done for speeding. Ticket says 90 in a 55. Cop states that he assessed the speed by tailing client for over a mile before pulling him over. My dad, what kind of car do you drive? Cop, Crown Vic. We all have Crown Vics. Dad, and how high does the speedometer go in your Crown Vic? Cop, 85. Dad, so, how can you be sure my client was doing 90? Dismiss ticket. And the cop and my dad had a good laugh about it afterward. Cop said he'd never heard of a going too fast defense before. This wasn't so much a bad argument, but an example of terrible questioning. This was a circular case, cleanup of polluted groundwater and soil. A witness, a former manager of the polluted property, was asked the following at a deposition. Q. Did you ever see anything strange? At that point, a number of objections to the question were made by the attorneys present. A. What? Did I ever see anything strange is your question? Q. Yes sir. Did you ever see anything strange? A. Yes. I saw a man with boobs. Q. You saw a man with boobs at the site? A. Number. I saw a man with boobs in New Orleans once. For the lawyer in the post, ask a stupid question, get a stupid answer. There was this defendant that was running a Ponzi scheme with a story about going into depleted mines in South America with new technology to recover previously unrecoverable gold. He was actually using half of the money to buy gold bullion to dazzle investors, and pocketing the other half. When they arrested him, they found a crap ton of gold under his bed. At his sentencing hearing a few years later, around 2011, it was argued that his sentence should be significantly reduced because, in the intervening time, the gold that had been seized had greatly appreciated in market value such that the investor victims would be mostly paid back in full, showing that his investment was actually prudent. That actually seems like a worthy argument. Not a lawyer, did work experience with one back in high school. He had to go speak to someone in the court cells, where I wasn't allowed, so I went and sat in one of the courtrooms while he did that. There were a few cases, but the one that stood out were the two guys who both had some injuries and claimed the other one had attacked them unprovoked. Neither wanted any representation. There was no evidence apart from them blaming each other, and when the lawyer I was with came to find me, they were literally just stood in front on the judge screaming he did it, no he did it, over and over again. Another story from a close friend who's a defense barrister. Her client was a building firm that had done shoddy work on an OPS roof that had led to it collapsing, causing the OPA head injury and fractured hip, so were being sued. She said the damages were wildly inflated in value by the prosecution, but her client was even more ridiculous with their offer. Her research had shown her that the minimum they should have been offering for the collapse of the roof alone, without the additional injuries, should have been £4,000. They refused to offer more than £1,600 on the grounds that they expected her to die before anything happened as a result of their work. She said she'd never felt more embarrassed than when she had to tell the judge this in front of the prosecution and their client. Not a lawyer, but was involved in recording proceedings of a case. The case was a major fraud case. It was multiple organizations involved and a lady was defrauding them through bad checks. She also had the IRS on her since she would use the receipt she got for the bad checks from charities to add deductions to her tax bill. I don't remember the exact amount of the money taken, but I remember it being something astronomical that made me surprised she hadn't been busted well before then. She was writing checks that she didn't have the funds to cover to charities. She would also write checks to herself, deposit it, and banks typically allow you to recover part of the check, typically $200-300 bucks. until it's fully processed and go through, and she would pull that money out of the ATM and use it for whatever. So there was a massive case built up against this lady by the state and these organizations, and she was facing several years in jail, and instead of pleading the fifth, she took the stand, and her defense was that since she was able to withdraw those amounts, it's the bank's fault the money is missing and not hers for the stolen withdrawals. She also tried placing blame on the charities for her IRS scam since they gave her a receipt to use. Total lack of remorse or responsibility about misuse of her checkbook to defraud organizations. Her defense lawyer managed to get the case drug out over months. That guy must have somehow been getting paid to delay the trial as much as he did to keep her out of jail. Lawyer, but not a trial lawyer. Corporate, so I never go to court. I will, however, relay a story one of my colleagues told me. This lawyer and a more senior lawyer were representing a defendant on some matter, and part of their argument relied on the plaintiff not mitigating their damages with respect to, if I recall correctly, a car accident. The plaintiff claimed that they were not able to get their car repaired because no shop in the city had time to do the repairs, or some flimsy argument. So during cross-examination, the senior lawyer from our firm asks the plaintiff which mechanics shops they had contacted. The plaintiff basically stammered and said they can't recall. Lawyer, well, let's see if we can refresh your memory. Pulls out a yellow pages phone book, drops it on the desk and flips to the mechanics section. Lawyer, starting with the first shop, did you call this shop? Plaintiff, no. Lawyer, goes to next shop in the phone book, did you call this shop? Plaintiff, no. Lawyer, goes through the entire section in the phone book, asking if the plaintiff has contacted any of the shops in the city. The answer is invariably no to each one, basically demonstrating that the plaintiff had taken no steps to mitigate damages. Lawyer, I'd like to enter this phone book into evidence. Judge, denied, on the grounds that I'm pretty sure we already have one around here somewhere. Not a lawyer, but was jury foreman on a particular case. It involved a college-age kid potentially going to the big house for carrying an illegal weapon. Long story short, the kid was from out of state and got pulled over, and the officer saw the weapon. The kid was arrested. In court, the defendant attorney introduced a document to where the kid that was riding in the passenger seat admitted it was his, but he would not come back to our state because he knew he would get arrested. Counsel starts reading off confession. After it was over, the prosecution objected to the document being presented. Both parties approached the judge and the argument ensued. Judge dismisses us because the courtroom was too small to keep the conversation quiet enough for us not to hear. After 10 minutes, we were called back in and everything proceeded. After all was done, we found the defendant not guilty. Counsel had an opportunity to question our decision afterwards, and prosecution asked me why we felt the way we did. I said the letter that was presented was enough to give us a reasonable doubt to the weapon being his. Prosecution was baffled. They said we were supposed to disregard that letter because of whatever the issue was. I said, but we came back into the room and everything continued. Nobody ever said for the jury to disregard. We heard what we heard and nobody said to disregard it. They ran back and sifted through the transcripts, and sure enough, they failed to inform the jury, myself in particular, to disregard the letter. Thus we used it to find the guy innocent. I am a corporate lawyer but did my debuts in criminal law and heard the most ridiculous defense from our client in a physical shaming assault charge. In a nutshell, he was accused to have assaulted a young girl by inserting his finger in her private parts. This all happened at a party, when the girl was trying to go on stage and he was kindly helping her to do so. His defense: I didn't do it on purpose. She was wearing a short skirt and my middle finger just slipped in her glory hole. The best parts? Spending hours with my colleague trying to find a rational explanation of how his fingers would have slipped and found itself in there, and plead this in court. Never felt so embarrassed. I was in probate litigation over my father's will against my brother, who was the executor. He was pro se and attempting to argue the interpretation of my father's ambiguous self-written will in such a way that it benefited him immensely. When the judge told him that he didn't think it could be reasonably interpreted the way my brother wanted, my brother argued with a raised voice that the judge was wrong and it was so obvious a third grader could understand it. There was a gasp in the courtroom at such a flippant remark. The judge kept his cool and said, "Well, you don't have a third grader. You've got me." By the end of the case, the judge removed my brother as executor due to mismanagement of estate assets. Still surprised he didn't get fined or thrown outright there for insulting the judge in open court. TLDR, insulting the judge's intelligence is not a compelling argument. If you are new to the channel, you can subscribe. I publish new videos every day. Until then, check another video. Bye for now.